All right. Court of Appeal in the Phipps State of Florida is now in session. Lambert, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Charlie. Good morning. Welcome to another session of oral argument with the 5th District Court of Appeal. As Marshal Charlie indicated, I am Judge Lambert. I'm presiding over oral arguments this morning. We have 2 cases live here. The panel to my right is Judge Harris, and to my left is Judge Sasso, who will, I'm sure will soon be the Chief Judge of our 6th DCA as that starts. So we're welcoming her in our unfortunately, our last times with us, last few months with us. But that being said, I'll stop being maudlin. All right. First case on our docket is case 21-2026, State of Florida versus Yahira Phipps. I apologize if I've mispronounced the first name. You'll have a seat. You're fine. Scaring me. All right, each side will have 20 minutes. The state, I will reserve 5 minutes for rebuttal unless you tell me otherwise. If there are any, if either of you have any cell phones or electronic devices, please just put them on mute or turn them off so that they don't inadvertently go off and distract either your counsel or yourself or the court. That being said, Ms. Davenport, if you're ready to proceed, you may.
May it please the court, my name is Chris Davenport and I represent the state of Florida. This is a state appeal from a trial court order suppressing the evidence gathered from a wiretap based on an error in the written authorization from the statewide prosecutor. Under the wiretap statute, before this intrusive investigative technique can be used, a political official has to approve it. The statewide prosecutor is one of those officials named in the statute. He did that here, but the authorization he signed had the incorrect phone number on it. It had an old phone number. Everything else was correct.
The application that the agent had the correct number on it.
The application of the agent was correct. The order was correct. The only place there was a problem was on the written authorization. And the only problem on that authorization was the telephone number. Which was typed on when it was provided to Mr. Cox, the statewide prosecutor.
And the actual wiretap evidence acquired was of the phone that was the correct phone, for lack
yes,
of a
the one that
better
was
term.
ordered by the judge, correct, yes. The target, the scope, the crimes, all of that was correct in the authorization. The application and the order had everything correct. There was no typo in there for the phone number. There's no challenge to probable cause in here in this case. The only issue that the trial court had a problem with was the incorrect phone number on the authorization.
I think you agree that the phone number is critical in a wiretap for the order and the application.
Absolutely.
So why should we view what was in the authorization as a Scrivener's error when it was a completely different phone number?
Well, because the record shows that it was a Scrivener's error, number one. Number two, the written authorization isn't even required. If the statute had language saying that you need a written authorization and it's subject to review by the court and it needs to comply with all the requirements of an application, that would be a different issue here. That's not what the statute said. The statute says the statewide prosecutor has to authorize it. So either because there was an error in the phone number, either the statewide prosecutor read the application he was given and decided, you know what, this is a good application, but I'm going to change the phone number that they tap, when all he has is the information provided by the law enforcement officer that contained the correct number. Or he got a different application with an incorrect number, and he decided he had 2 competing applications, and he decided to choose the incorrect phone number one. But there's no evidence of that. If there would be 2 applications here, this would be a different issue because we wouldn't know what he intended to authorize.
Does the incorrect phone number, using that term, does that phone number have anything to do with anybody in this case?
It's an old phone number that this target had used in the past. They actually had a pen register created for that number, and they had done something to get his address from that phone number, but it was an old number. This defendant changed his number frequently to avoid this kind of situation.
Would this argument
presumably.
hold if it was, you know, a search of a residence and it was the wrong address, or if, you know, the authorization was for whatever the current phone number of the defendant is?
I'm sorry, I don't understand your question.
Yeah, so if we look at it, you know, in terms of, let's say it was a completely different address. This didn't involve a phone number, and it's a completely different address. Would that logic hold if there was a different address in the application and the authorization?
Yes, if it was a typo in the authorization for the address, well, I mean, wiretaps don't usually have an address. But let's say they hadn't,
Right. I'm thinking
say
something
that
other than
there's
that.
a statute that covers any warrant, and we need authorization for all of them. And the address in the application and the address in the order and the warrant was all correct, but the authorization had an old address in there, I would submit, yeah, it's still a typo. And again, unless the statute requires some scrutiny of the authorization, then I would say that's not a core concern of the statute and it doesn't require exclusion. If all we had here was that affidavit, was the authorization from July 6th with the wrong phone number on, I would submit that the trial court would have erred in granting this motion to suppress, because you can't suppress based on a typo. I've submitted a lot of cases finding similar areas only, you know, in the application itself or in the order, and they went back and corrected it, and the court said, we're not going to exclude the evidence based on this typo. But we have more than that here, too. We have the email from the prosecutor that was introduced by the defendant where she said, Mr. Cox, I'm sorry we sent you the wrong documents. Here's the correct authorization. And he went back and signed that nunc-pro-tunc. And I know that doesn't
Is there any legal
have...
significance to the nunc-pro-tunc designation on that second authorization?
Yes, I think there's great significance to that, and that every lawyer knows what nunc-pro-tunc means. It means I'm memorializing what I did before. He didn't sign it just, okay, I'm doing a new one for July 9th. He signed it nunc-pro-tunc, which indicated he realized there had been a problem, as the prosecutor explained in her email, and his intent was to authorize the number that was found in the
There
application.
may be some factual significance. Is there any legal significance? Can a lawyer do something nunc-pro-tunc?
A lawyer cannot technically do something nunc-pro-tunc,
Oh, it's
no.
meaningless legally.
Well,
You file a notice of appeal in State v. Jones on the last day. A week later, you realize you meant to file it in State v. Smith. Can you do another notice of appeal and nunc-pro-tunc it back a week?
no.
And how can Mr. Cox do something similar?
Well, Mr. Cox can't do something that has legal significance. He can't
That
backdate
was
an
my question
order.
at
He's
the
not a
end.
judge. But it shows his intent.
But there's no legal significance to it.
There's legal significance in that it shows his intent. You know, when he signed something with that, using nunc-pro-tunc, why else would he
Need
do
the written
that?
authorization. He didn't even need to make it nunc-pro-tunc, did he?
No, he didn't need to.
That was kind of my point.
Right. He didn't need to. I'm saying if all we had was this July 6th application with the incorrect phone number, this trial court still would have erred. But we have a lot more than that here. We have the sworn application by the law enforcement officer who said, Mr. Cox authorized me to file this application. Sworn testimony. The prosecutor was going to call him as a witness. The trial court said, I need to hear from Mr. Cox. You're wasting your time here. And the prosecutor didn't call him, but she proffered that testimony.
And what
she
you're
said-
saying, is Mr. Cox, the statewide prosecutor, didn't even actually have to submit that original application form that had the incorrect phone number for the wiretap to have been granted by Judge LeBlanc based upon the agent's written
Correct. Mr. Cox had to authorize it.
Right.
But
Which-
all that
which
we
is-
really need.
And that's what the
is-
agent's document said, this is
That's
authorized.
what the agent's document
The agent
said,
just
yeah.
didn't one day wake up and say, oh, by the way, I'm going to ignore Cox, I'm just going to go ahead and do this.
Exactly. We didn't need this at all. Both parties agreed that there's no written authorization required. If they could have done this by telephone, if they had done it by telephone, they would have talked about the investigation. They probably would have mentioned who the targets were. I really doubt that he would have said, let me give you this phone number, Mr. Cox, and write this down and make sure that you agree to the phone number. He's not an investigator. He's a supervisor to make sure that the investigation warrants this technique. He's not there to double check all the dot your i's and cross your t's, so to speak. That's not what he's there for, and that's not what the statute requires. The statute requires who authorizes the application. It doesn't require how it's done. It doesn't require a certain level of sophistication.
And basically, after the fact, at the later hearing, Mr. Cox says, look, I never intended for the wrong phone number to be wiretapped, and there was no evidence contrary to that, was there?
There was
Other
not.
than the actual existence of the July 6th
Right.
application that he
incorrect phone
signed
number
with the
application.
wrong number in the
Right.
first place.
That was the only evidence that
That's the only
the
thing
trial
that
court relied
contradicts
on.
his statement after the fact, saying, well, I didn't authorize some number that I had no interest in having a wiretap. I meant it to be the right one, which they eventually then got the wiretap evidence from that one and only that one.
Exactly. That's exactly what it testified. Now, the trial court said, I'm not going to consider your testimony because you should have come at the first hearing. You know, there's some question about that.
Is that
even
not within the
without
trial
that.
court's prerogative, though? I mean, this was they could have made Mr. Cox available at the first hearing. It was a motion for rehearing. There's no indication that trial court felt it was obligated to consider the testimony and could have just rejected it from the basis.
The court was not obligated to grant rehearing and allow the presentation of that. Now, in fairness, since he would only listen to that witness, which took the prosecutor by surprise, I think in fairness, he should have done that. And the court did do that and then said, you know, I'm still not comfortable. It seemed to me that what the court was looking for was Mr. Cox to say, yeah, I paid attention to the phone number, and this 270 number was the one I really intended to authorize the wiretap for.
And so why would that not have us engage in some reweighing of the evidence? If the trial court heard that testimony, and I think you've recognized that the nunc-pro-tunc is relevant to intent, and the trial court made a determination as to Mr. Cox's intent based on the evidence it heard, why are we in a position to be able to decide differently?
But because there wasn't any conflicting evidence on his intent. The only conflicting evidence was, well, and really there was no conflicting evidence of this. He didn't pay attention to the phone number. The question is, should you suppress a wiretap because the authorizing official didn't pay attention to the phone number?
Is it that there needs to be conflicting evidence, or is it just within the trial court's province to reject the testimony as unpersuasive, maybe based on demeanor or something that we don't have the ability to appreciate?
Yes, the court can always reject testimony based on demeanor. But without Mr. Cox's testimony, we still have all that we need to say that this should not have been suppressed. Again, if all we had was the July 6th authorization, it's a typo in there. That's clear by the fact that the nunc-pro-tunc one is exactly the same except for that phone number. It's clear because of the fact that there was only one application in this case, and it was for the correct phone number. It's just a typo, and case law makes it clear that we don't suppress evidence based on a typo. If the court has no other questions, I will reserve the rest of my time. Thank you.
Okay, thank you, counsel.
May it please the court. So the issue here is a question
I'm
of...
sorry, who are you? I'm sorry, what's your name?
I'm Laura Sapiro on behalf of Yahira Mojica Phipps.
You're Laura Sapiro?
Yes.
Okay, all right, thank you, ma'am.
The issue here is a question of fact, and the trial court was in the best position to determine the credibility of the witnesses on that case. The state asserts that this was just a typo. However, that is not supported by the evidence or the case law. For example, in De La Fuente 548 F2D 528 at page 537, it says, "We have previously held that clerical errors resulting in an incorrect digit or inversion of digits in target telephone numbers do not invalidate a wiretap application or order." I point to that. It says incorrect digit, singular, or inversion of digits. That is not what occurred here. This is an entirely different phone number. An inversion of digits or an incorrect phone number, we could chalk that up to just a slip of the finger. This is not what happened here. It's a completely different phone number, so it's not merely a typo. And then I also want to point out
Is there
that...
any relationship between this phone number and the defendant?
No, it's the target suspect's phone number, but she is the sister of him. So eventually, the wiretaps that came after that, there were several orders that eventually led to Ms. Phipps.
So her brother is Hector, and this was Hector's phone number?
Yes, correct. Also, the trial court, as I said, was in the best position to make factual determinations, and they did that, and the defense met its burden in this case. So it wasn't merely the July 9th authorization that was nunc-pro-tunct that was evidence of competent substantial evidence of illegality. It was also the July 6th authorization with a different phone number, and also the email that the ASA sent on July 9th saying, we sent you the wrong documents containing the old phone number. It says documents. She doesn't clarify in there what that was. We don't know if the other documents were a different application. Maybe she attached something different. And the state did not present the emails with the actual attachments itself.
So you're saying the trial court was unpersuaded, and we're bound by the trial court's analysis of the evidence that even though the agent has the correct number, the supervisor, Mr. Cox, decided to sign an application with an entirely different number, and he comes back after, that happens on a Friday, he comes back on a Monday saying, I don't mean that other number, I meant the one that the agent had who's working the case, that the judge, we're bound by the judge saying, well, you didn't really mean that, Mr. Cox, you really meant to have the original number on your application as the wiretap target.
Well, I think at that point the burden had shifted to the state to show that there was merely an official oversight, and the state didn't meet that burden.
Why not? I mean, what else would the state have to do? I mean, in the sense your whole case, your whole motion is premised on the fact that there is an application signed by Mr. Cox that has a number which is inconsistent with what Judge LeBlanc's order and what the agent's application has. And Mr. Cox comes in and says, that's not what I meant at all, some other random number. I meant the one that the agent who was working the case, that's what I wanted to have wiretap. That's what I authorized in the first place. And there's nothing other than the piece of paper that has the wrong number on it that contradicts that.
Well,
am I missing, what else are you relying on to say that that's...
I think that the trial court made a determination that Mr. Cox's testimony was not credible. If you look at how he testified, he gave his usual procedure. He says, I typically send an email authorizing the application. I usually follow up with an email. They didn't provide those emails where he followed up saying, okay, I'm going to approve this and then I'll sign the order later. He was equivocal about whether he paid attention to the number. He says, I'm not mindful of that. Well, he needs to be mindful of that. This is very important. The legislature has made a determination that we need to provide additional protection to wiretaps. That's why they passed the statute in the first place. So he needs to be mindful of the number. And he also, just his general discussion of his procedure, he testified originally that the reason why he signed the order nunc-pro-tunc was because it was a Saturday, he wasn't in the office. And then he realized, oh, well, I'm sorry, I just assumed it was a Saturday, it was actually a Friday. So I'm assuming that the reason why I didn't sign it is because I was not in the office that day. So that just kind of showed the court that he was testifying about what he normally does. He didn't have an independent memory of what happened here. And it just, I think that undermined his credibility about all of his testimony. So to the court...
So in essence, then, the trial judge would have to look and say, okay, you presented with something from your agent with the correct phone number. You, Mr. Cox, went out of your way to put a different phone number in the application for reasons that nobody can explain. And that's really what you meant, and your testimony has not persuaded me as the trial judge that you actually wanted to have the correct phone number tapped. You wanted some random phone number tapped instead.
Well, I don't think it's necessarily that. I think that the trial court looked at it and just said, I'm not convinced that he was paying attention to all of it because he wasn't looking at the phone number. Like I said, it's not a typo. It's completely different number.
Well, he pulled the phone number out of the blue somewhere?
I believe from my understanding of the evidence is that when the email is sent to him with the application and the documents, they also set up an authorization itself prepared for him already, and then he signs it. I don't think he's the one that writes up the authorization, he just signs it, from my understanding of the evidence.
What is your response to the argument that, credibility issues aside, the state had everything it needed? This didn't turn on Mr. Cox's testimony, but rather on the fact that there's no actual written authorization required and that this is all hyper-technical scrutiny of something that doesn't even need to exist?
Well, it's not required, but when the state chooses to do a written authorization, they need to do it correctly. to give confidence in the court that it was authorized. And because they did not do it correctly, that raised an inference that there was something wrong here and that perhaps there was some other application or they intended it for a different phone number. So when they do it written, it needs to be correct and give the trial court confidence in that.
So,
Would that be kind of a, sorry, go ahead.
No, you go ahead, you're right.
Would that be a novel position in Florida law if this court was to write that in an opinion? That if the state is going to do a written authorization, that there's these several technical requirements that must be complied with, otherwise a court?
I don't think it's necessarily that there need to be technical requirements so much as that there shouldn't be anything in it that raises an inference that perhaps the authorization was not authorized or not correctly for that particular phone number. We have a particularity requirement under the Fourth Amendment. I think that needs to be followed when we do a written authorization or choose to do a written authorization.
It seemed like your brief acknowledged that Mr. Cox's application wasn't even required to get the wiretap order signed by Judge LeBlanc. So if I'm then following the dots here, the document that had the incorrect number was never even needed in the first place. Judge LeBlanc had everything in front of him that he needed to authorize the wiretap with the correct number, but fortuitously, because there's an application that has an incorrect, an inadvertent incorrect number, that therefore it should be suppressed, even though it's a document that is not required for the wiretap order in the first place. Is that right?
Not exactly. So the written authorization, it provided the competent substantial evidence of legality that the defense needed to show in order to shift the burden to the state.
But if it wasn't there, I mean, the agent never had to show up with that piece of paper from Mr. Cox on the day
Correct.
he walked in front of Judge LeBlanc and said, hey, can I have a wiretap order? And that's typically what happens. I mean, as a trial judge, as a felony docket, that's typically what happens. I mean, you never heard from the statewide prosecutor, so you have that document, and that's what you go on as a judge to see if that's legally sufficient to issue the wiretap order. And because there's an extraneous document, which they're entitled to prepare, but is unnecessary for a trial judge to consider because that has an incorrect telephone number, which everybody seems to, nobody tried to wiretap that incorrect phone number. That seems to be the tail that wags the dog here because the judge isn't persuaded from a legal standpoint down the road that, you're relying on something that was never necessary in the first place to deny the motion for rehearing or reconsideration. Isn't that kind of the lay of the land right now?
Well, what I would say is that the document was not required in the first place. However, it gave evidence of illegality or that there may have been an error. So in that case, it's not just that order, it's the two orders, the July 6th one with the wrong number, the July 9th one signed after the wiretap order, and then the email saying it's the wrong document. So all of that together.
That application form is wrong, and then the person who provided that unnecessary document said, look, that isn't the number that I authorized to wiretap. That is got a wrong phone number on it, Judge. That's what happens. I'm, mea culpa, I'm sorry. I don't know why that doesn't make the wiretap order okay.
It would be okay in the case that Mr. Cox gave testimony that gave the court sufficient confidence that he did actually do it. So it's not just the order, the written authorization itself. It's also that the state failed to prove that he did authorize it.
So actually then the better route the state, if I'm following this through my illogical analysis here, is when they had the motion for rehearing, the state should have said, you know what, Cox, you may not be the greatest witness we ever saw, even though you're a statewide prosecutor. We don't actually need you. Stay on the sidelines. We're just going to rely on the fact that we never needed it in the first place and tell the judge that you don't have to do that, Judge. You just had to look at the agent's affidavit, and that was sufficient for the wiretap. That probably, based upon what I read in the record, that probably wouldn't have assuaged the trial judge at that point.
Well, at that point, the burden had shifted, so the state needed to put on some evidence. And as you suggested, they could have done the agent's evidence, or his testimony. The agent, however, would have just testified that he sent the documents to Mr. Cox. The trial court needed some testimony that he actually reviewed it and made sure that he was authorizing the correct phone number. So they would have needed Mr. Cox's testimony to give the trial court confidence in that.
Okay.
Do you see the framing of this issue as a competent substantial evidence issue or as a kind of legal issue as to which subsection under the, or I guess subsection under the statute should have been pursued? And
I believe it's a competent substantial evidence issue because no one's saying that a written authorization is required. This is just a question of fact. So there was competent substantial evidence based on the two authorizations, the one with the wrong number, the one with the correct number dated July 9th, and then the email. That shifted the burden from the defense to the state to prove that it actually was authorized, and they failed to provide competent substantial evidence of that. And as I said, the trial court was in the best position to determine Mr. Cox's testimony. He was wavering, he was equivocal, he wasn't sure about the date, he just made assumptions about why it was the way it was. He said, I assume it was a Saturday, and it wasn't. He was talking about what he normally does instead of what he actually did in this case. And in that, under those circumstances, the trial court determined that that was not competent substantial evidence, and the state did not meet its burden at that point.
Okay. Anything else?
If there are no further questions, I'll yield my time.
Okay, thank you, counsel.
Thank you.
All right, Ms. Davenport.
May it please the court, just a couple of points. First of all, as to the equivocation by Mr. Cox on page 474 of the record, the prosecutor said, so when you authorized the application via email, was your intent that the authorization was for the telephone number 270, the correct telephone number? Yes, ma'am, because those were the documents that you sent me. Yes, ma'am. That's not equivocal. He started out a little confused, but once he got into it and started reviewing the documents, that was his testimony. But again, we didn't need that testimony. The prosecutor tried to fix this below. The trial court wanted to hear from Mr. Cox. Apparently, that is an ongoing conflict with this judge that involves our civil division and a lot of things that are way beyond this case. And the prosecutor said, if you need to hear from Mr. Cox, we're going to call Mr. Cox because we want this to be fixed. We don't want to have to wait for an appeal. And she tried to fix it, and it didn't work because, in my opinion, because Mr. Cox said I didn't pay attention to that phone number. So that was what the trial court was concerned about. It's a legal issue whether or not an error in a phone number, a scrivener's error in a phone number on a document not required by the statute requires or allows suppression of the wiretap evidence. And we would submit the answer to that question is very clear under the statute. This is so attenuated. If he had signed an authorization for Michael Smith, who's a child trafficker, and that was what he signed, and that's what the substance of his authorization was, I think that would raise a question whether or not he actually read the application.
And that
paid
broader
any
question may be legal, but is the issue of whether or not it was in fact a scrivener's error, would that be factual or legal?
I think whether or not something's a scrivener's error versus a error that requires exclusion is a legal question. If this is a competent substantial evidence question, there's no competent substantial evidence. If we're going to allow the trial courts to start going behind these questions, whether or not Mr. Cox paid sufficient attention to this application and reviewed it in enough detail, I think that's going to open a whole can of worms. That's not required by the statute. The statute says who needs to do it, not how they do it. And so I would say if that's what the standards are going to be, that's going to raise a lot of problems in these cases, and it's going to require the statewide prosecutor or the attorney general or the state attorney. I mean, it's not just statewide pros that does these wiretaps to have to come in and testify and say that, yeah, I'm paying attention to the address and the phone number rather than I'm looking to make sure this is the type of investigation that warrants a wiretap because that's my job under the statute. I think that would be contrary to legislature, what the legislature set out here. I think it would be a bad policy. This is a legal issue. The trial court legally erred in suppressing this evidence based on what is essentially a scrivener's error in a document not even required. And we would ask this court to reverse.
All right.
Thank you.
Thank you, counsel. All right, we'll stand adjourned. We're going to have a panel change. Judge Sasso's on a one case per day contract with us now. We'll have Judge